Welcome to the final quarterfinal round for the International Mock Trial 2026 February-March competition. We began with 48 teams. We are now down to the Elite Eight, and we formed a very prestigious judging panel to ensure that only the best moves on to the Final Four and semis. Congratulations to both teams for making it this far. I'm going to begin by introducing you to your presiding judge. That's Miss Melina Gatson of Emory University. Judge Gatson, please take it away.
Hi, everyone. Um, as Ian just said, I am competing for Emory University mock trial. This is my second year in AMPTA. I've also done high school mock trial, just about every competition that there is out there in high school. But I'm looking forward to a good round. Good luck to both teams, and congrats on making it this far. I'd like to also pass it over to our two scoring judges as well.
Hi everyone, my name is Lexi. I'm a competitor on the University of Wisconsin mock trial team, and this is my second year in AMPTA. I'm so excited to see what you guys put together today, and good luck and round.
Hello, everybody. My name is Tim Hoyenga. I'm a former competitor on UCLA's mock trial team. I was on Ian's championship team in 2014 for UCLA. I've competed at all rounds of mock trial, and I'm currently a deputy district attorney here in California. So, good luck to everybody.
And with that, calling the case of the state of Tilly versus Nova Wölff. Can I have attorneys please make appearances?
Yes, Your Honor. Your Honor, first, may we ask for your time zone, please?
Yeah, I'm in the Eastern, so it is 11:25 in the morning for me.
Yes, Your Honor. So that would be a good morning, Your Honor. My name is Angela Fang, along with my co-counsel, Ms. Musani.
Good evening, Your Honor.
And oh, collectively, we represent the prosecution in today's case.
Okay. Defense appearances?
Yes, Your Honor. Good morning, Your Honor. My name is Christiana Garcia, and today I have the pleasure of being joined by my friend and colleague, Elizabeth Liu.
Good morning, Your Honor.
Together, we represent our client, investigator Nova Wölff.
Okay, sounds good. Prosecution, do we have any pretrial matters before we get into it?
Yes, Your Honor. So first, we would like to evoke Rule 603, which is the swearing in of all witnesses.
Okay, it shall be invoked.
And next, we would like to evoke Rule 615, the constructive sequestration of all witnesses other than the party representative. And just by the way, the prosecution's party rep would be Cotter Ashlock.
Defense, is that your understanding?
Yes, Your Honor, and we'd also like to designate our client, investigator Wolf, as our party representative.
Okay, sounds good to me.
Your Honor, we would also like to ask Your Honor's preferences for screen sharing. Would we ask for permission every time or simply let the record reflect?
You can let the record reflect.
Yes, Your Honor. And we would also like to ask Your Honor's preferences for objections. When a motion is sustained, should we motion to strike?
Yes, motion to strike.
Yes, Your Honor. And lastly, prosecution would like to read into case law, which is permit office enforcement versus citizens for no permit office enforcement, which states that restraining a person with no or minimal intention of stopping a crime is not an act of citizen's arrest.
Okay, defense, that's your understanding of that case law?
Yes, Your Honor.
Okay,
Yes, Your Honor. So with that, prosecution is ready to proceed.
sounds good. Defense, any matters?
Yes, Your Honor. First, we'd like to put the court on notice that we're pursuing an affirmative defense today called a citizen's arrest.
Okay, understood.
We'd also like to bring the court's attention to Stipulation 11, which, as we can see on screen, states that Nova Wölff is a private detective certified by the Tilly Detectives Association.
Okay, so noted.
With that in mind, Your Honor, we'd actually like to bring the court's attention to a case law.
All right.
That case law is Tilley v. Swift v. Ham, 1989, which said a precedent that licensed private detectives are not compelled to cease investigations when instructed by law enforcement, so long as those investigations independently do not violate the law.
All right.
Lastly, Your Honor, during our meet and confer with opposing counsel, we both went through specific character traits we are going to be offering of Investigator Wölff under 404A2A, and my co-counsel will now be putting those into the chat.
Okay, so we only have notice for just and law abiding. That's my understanding here.
Correct. Those are the specific pertinent traits we're offering for Investigator Wölff, and we covered with opposing counsel.
Okay, I will keep that in mind. Anything further?
No, Your Honor. With that, we're ready to get this ball rolling.
Okay, in that case, prosecution, opening statement.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. She chose a cage over a call. Late night, Corleone was asleep, but the defendant was waiting. When she noticed a former criminal right in front of her house, her eyes gleamed. Not with fear, not with nervousness, but excitement, as if a predator has just saw its prey. For almost a decade, the defendant has been hunting down the Ashlocks. She stalked, harassed, wrote threatening emails, and even sent a blade smeared with blood. Cloaked in the name of justice, she relentlessly sought for personal revenge. And this time, as she finally got her chance, the defendant darted out, knocked the person unconscious, dragged her 3 flights of stairs into her basement, and the next thing we knew, she chose a cage over a call. Members of the jury, today we'll learn about a so-called detective who hid behind this title to pursue a personal vendetta. On the night of the incident, she held a knife to Cotter Ashlock and stripped her of her freedom. But when the police called looking for Cotter Ashlock, she said nothing because she chose a cage over a call. For this, the state is charging the defendant with 2 charges: second-degree unlawful imprisonment and interfering with an officer. We take a burden to prove that beyond a reasonable doubt, the defendant illegally confined Cotter Ashlock, used unreasonable force against Cotter Ashlock, and intentionally hid Cotter Ashlock from the police. To meet our burden, we bring you 3 facts. 1. The defendant wanted revenge. 2. The defendant confined at knife point. And 3. The defendant hid it from the police. First, the defendant wanted revenge. We will call Officer Corleone to the stand. As the lead investigator assigned to the case of the Ashlock family, he will prove to you how the defendant relentlessly pursued revenge after her friend was poisoned in an incident tied to the Ashlock family. You will learn how she hated the Ashlocks and would stop at nothing. Second, the defendant confined at knife point. Cotter Ashlock, the victim of confinement, will take the stand and explain how she was held against her will that night. You will learn that the defendant used unreasonable force to confine her and interrogated her under the threat of a knife. Members of the jury, you don't have to take Ashlock's word alone. You will find that her account is corroborated with evidence and sworn testimony of other witnesses. And third, the defendant hid it from the police. Today, multiple witnesses will mention a phone call between the defendant and the officer that night. You will learn that despite being fully aware that the police was searching for Ashlock, the defendant kept silent, as Cotter Ashlock was sitting right in her basement. She chose a cage over a call. Members of the jury, this case is simple. All the defendant had to do was to call the police. Dial 911 on their phone and call the police over to arrest the criminal. But she didn't. She chose a cage over a call. And that is why, at the end of this trial, my co-counsel, Ms. Musani, will come to the stand and ask you to find the defendant guilty. Thank you for your time.
Thank you. Defense?
Yes, Your Honor. She captured a criminal to stop a crime. A criminal named Cotter Ashlock stands feet from the home of investigator Nova Wölff. She's not there by coincidence. She's there to commit a crime against the investigator who put her entire criminal family behind bars. Moments later, investigator Wölff hears a disturbance outside. Unexpectedly, she steps into the dark night, and suddenly, the criminal reaches into her jacket, pulls out a knife, and launches to attack her. In that moment, investigator Wölff has a choice: die or fight for her life. Today you'll learn she chooses to exercise her lawful right to self-defense, disarming and detaining the criminal in her home, not in a cage, until the police came. Because today you'll see Miss Fang has it wrong. That Miss Ashlock was the one to choose a crime over calm. And that's why investigator Wölff captured her. Because today, when the state chose to charge her with 2 felonies overlooking the real criminal, they took on the highest burden in our legal system: proof beyond a reasonable doubt. And today we're confident they will meet that burden. And that's why we brought forth an affirmative defense of a citizen's arrest. Now, let me spare you years of law school. Simply put, if we prove that it's more likely than not she witnessed a crime, she used reasonable force in her capture, and she contacted the police within reasonable time, you must find her not guilty. So, folks, let's walk through those 3 facts: the crime, the capture, and the contact. First, the crime. Today you'll hear from a resident of the neighborhood that she heard Miss Ashlock pull out a knife when speaking to investigator Wölff. Today the evidence will show that only investigator Wölff's DNA was not on that knife. It was only Miss Ashlock's. And you'll learn that knife solely belonged to her. And after that, you'll learn about the capture. You'll learn that every citizen has the right to defend themselves using reasonable force. That doesn't mean being as gentle as possible. It means when you see the evidence, it will show you that investigator Wölff's actions of disarming the criminal, tying her up, and keeping her in her own home to prevent further crime was reasonable. So lastly, you'll learn how she contacted the police. Because contrary to what the defense just told you a moment ago, this case isn't as simple as picking up the phone and call 911 because of one thing you'll learn today: that this criminal wasn't cooperating, that she was threatening, trying to fight investigator Wölff off. So today you'll learn that the second she got the opportunity to, she contacted the police. Because she captured a criminal to stop a crime. Moments ago, the state claimed investigator Wölff hid behind her title to act on personal acts of vengeance, stopping at nothing. But when you take a look at the knife, the timeline, and the evidence, it will show you this case isn't about revenge, it's about self-defense. Today, as jurors, we'll ask you not to stop until justice is served. When you do, we expect that you'll find her not guilty, because she captured a criminal to stop a crime.
Thank you. Prosecution may call your first witness.
Yes, Your Honor. Prosecution would like to call Officer Larry Capolino to the stand. Good day, Mr. Capolino. Can you please introduce yourself to the members of the jury?
Good day. My name is Larry Capolino.
Sir, what is your occupation?
I am a sworn officer and trained investigator in the Corleone Police Department, currently assigned to the Major Crime Division.
How did you get into this line of work?
When I was younger, my friend was accused of theft. From that day on, people drifted away from him. Everyone pointed fingers, and no one believed his words. I couldn't prove him innocent. A few months later, he committed suicide. Back then, I couldn't prove anything to anyone. But now, I can, as an investigator.
Thank you so much for sharing, officer. What are your qualifications in these fields?
I graduated from Maple Police Academy with significant training in investigative techniques, evidence handling, as well as crisis negotiation.
Could you please elaborate on your career after graduation?
Of course. Since my graduation, I have participated in over 50 felony investigations. I have served with the Corleone Police Department for more than 10 years, involved in many cases related to the Ashlock family.
Why was the Ashlock family investigated in particular?
Our department has arrested many Ashlock family members in the past. From questioning and previous investigations, we discovered that many major crimes related to this family.
Officer, let me bring you back to today's case. Why are you in court today?
I'm here to provide my investigation regarding the claimed kidnapping and assault of Cotter Gabriel Ashlock, along with my personal experience with Nova Wölff.
How did you conduct your investigations?
Our investigation was conducted by many of our dispatch investigators. Our investigation revolves around the CCC process, and I've brought a demo today to present it.
Your Honor, let the record reflect that we're now screen sharing the witness's demonstrative. What is this process, sir?
The CCC process stands for connect, collect, and conclude.
Is this method commonly used?
Certainly. It is a golden method in my field.
Officer, how did you apply this method in today's case?
I'll start with the first, connect. I have found several connections related to the individuals of today's case, and specifically the defendant.
Sir, do you know the defendant?
Yes, I do.
How did you know her?
Our first encounter was in an investigation of Ashlock safe houses, with Wölff as a private investigator providing our department with some of the Ashlock safe house locations, as well as detective tips. Later on, she reached out to us personally to aid our investigations to the Ashlock family. You can say that we work together. Though, that is where I learned about her means of operation.
What are her means of operation?
During our missions, I saw her approach Ashlock members several times, seeming to have a conversation. Wölff was pressing on with her physical gestures and shouted things I couldn't make out clearly. I wondered why she was always investigating the Ashlocks. And a connection explains everything.
What was the connection that you mentioned?
I regret bringing this up, but our team investigated the personal relations of a victim that was poisoned to death tied to the Ashlock family. Wölff was found to be their close friend. Since then, Wölff began her persistent personal pursuit of the Ashlocks. I warned her more than once that vigilante justice was not right.
Officer, let's move on to your second procedure. On the day of the incident, what evidence did you collect?
Starting with phone calls. It was March 6th when I was notified that Cotter Ashlock was released on parole. Concerned about vigilante actions, I called Wölff, but she did not answer. I then left a phone message telling her to call me back.
So, did you receive any response afterwards?
I did. I received a call from Wölff regarding my voice message on Cotter Ashlock during the night of the incident.
Your Honor, let the record reflect that we're now screen sharing what has been pre-marked as Exhibit 4B. Sir, do you recognize this exhibit?
Yes, it is a transcript of the call I just mentioned.
Is this a fair and accurate copy?
It is.
Has it been altered in any way since you last saw it?
No.
Your Honor, prosecution moves to enter Exhibit 4B into evidence.
Any objections on 4B?
Yes, Your Honor, as to hearsay, specifically this witness's statements.
A response to the hearsay?
Response, Your Honor, this is an hearsay exception as this goes towards the regular conducted activity. So this goes towards the call that every call that happens at a police department, it would be automatically recorded. So this is a regular conducted activity at the police department.
Response, Your Honor?
Response? Yes.
Yes, Your Honor. In order for Ms. Fang to get this document in under Rule 8036, she needs to meet all 5 prongs. Your Honor, I don't believe that's happened yet.
If I may, Your Honor.
You may.
So here we would like to just list out the A, B, C, D, E of the regular conducted activity. So first of all, the record was made at or near the time by the night of the incident, which has been said on the exhibit, which I believe is around 10:50. And it is also made by someone with knowledge, which is my witness, Officer Capolino. And the next was that the record was kept in course of regular conducted activity of an organization, which is the police department. And third, making the record was a regular practice of that activity, as it is common knowledge that in the police department, every phone call made was just automatically recorded for the police's investigations. And fourth, all these conditions are shown by the testimony of a custodian or another qualified witness, and I believe that that witness would be Mr. Capolino, as he is an expert in police investigation. And lastly, neither the source of information nor the method of circumstances of preparation indicated a lack of truthworthiness, and that is exactly that I mentioned before. As my witness is an expert in investigations, this is qualified.
Response, Your Honor?
Yeah, I'll give you the last response, defense.
Yes, Your Honor, 2 layers here. Number 1, Your Honor, if Miss Fang, or rather if the witness testified to what Miss Fang just said about prong B and C, we wouldn't have any issue. But the witness never said anything about a regularly conducted activity. He never said that he knew this record was kept in the course of that regularly conducted activity. And secondly, Your Honor, we don't believe this witness actually meets the prongs of 702 to be qualified as a police, or rather as an expert in police investigations, and I'd be happy to explain if Your Honor would like.
No need. I'm going to sustain. I don't believe we've had enough foundation for the 8036 exception. If any other issue comes up with expert testimony, you can take that on later, defense.
Yes, Your Honor, understood.
Your Honor, may we lay that foundation right now?
You can try to enter it again, yes.
Yes, Your Honor. Officer, is recording phone calls at the police department a regularly conducted activity?
Certainly. With phone calls made at the police officer and office, we will definitely be recording our interactions with any phone calls every time we make them.
Your Honor, prosecution now re-enters Exhibit 4B into evidence.
Defense?
Yes, Your Honor, objection still as to prong B. Opposing counsel still hasn't laid the foundation that this specific record was kept in the course of that business.
I tend to agree, prosecution. I'm going to sustain again.
Yes, Your Honor.
Your Honor, Your Honor, I don't really understand the defense's objection as to the course because my witness has already explained that this record has been kept in the police department.
Response, Your Honor?
Well, okay. The issue is that your witness is not like specifically testified to how it's kept and if it's regularly kept in this department. We just need more foundation for that particular prong at this point.
Oh, yes, Your Honor. We'll lay that foundation right now.
Okay.
Mr. Capolino, do you know where that the course of these phone call transcripts are restored in the police department?
In recording these calls we make with particular individuals during our times of office, we will be recording, and then the recording will be transformed into a transcript, which will then be kept as paperwork in our department storage.
Your Honor, prosecution now moves to enter Exhibit 4B into evidence.
Objection, Your Honor. Yes, Your Honor, as to Rule 404, character evidence.
Could you explain?
Yes, Your Honor. Specifically on the second page, this witness says, "We both know you have a habit of hiding things from the police." Your Honor, that's certainly improper character evidence.
Response to that.
Response, Your Honor, this is not improper character evidence, as my witness has just testified that he had private relationship with Nova Wölff as being colleagues in a police investigation work, so that it is a very rational perception that my witness has knowledge of Wölff's habits and personal behaviors when investigating. So we believe that this is not improper character evidence.
Response, Your Honor?
Yes.
Your Honor, the defense's issue isn't with this witness's familiarity with Investigator Wölff, but rather the propensity that this statement goes towards. It verbatim says, "We know you have a habit of hiding things from the police." Your Honor, we have a good faith belief the prosecution is going to use this to prove propensity, to prove their second charge of obstruction. Your Honor, in this case, it's certainly being used for the truth, and it's certainly being used for its propensity value.
Defense, what trait is that eliciting here?
Oh, yes, Your Honor. This goes toward the pertinent trait of motive, as we have offered character evidence form of Nova Wölff's past acts before this trial.
Response, Your Honor?
Briefly.
Your Honor, we believe this is going towards the trait of dishonesty.
Your Honor, if I may.
You may.
We believe that this goes towards the pertinent trait of motive, as this is testifying against Nova Wölff's past hostility, specifically towards the Ashlock family case, instead of a dishonesty as an investigator as an entity.
Last
Defense, is that the only line that you take issue with here?
My apologies, Your Honor. Yes, Your Honor, that's the only line we take issue with as of right now.
Okay, in that case, I'm going to sustain the 404 to that particular line. It should be stricken from the exhibit. If
Yes,
there's
Your Honor.
no other objections to Capolino's words coming in onto the record, I'll admit 4B.
Yes, Your
Yes, Your
Honor.
Honor. Sir, let's bring back to the question. So, officer, what did you discuss in this call?
I advised I advised her not to take any action, but she responded, "I will defy you then." Then I heard sounds and heard footsteps, and our call ended abruptly. I was concerned.
Officer, could you describe the sound for us?
The crashing noise sounded with familiarity to bludgeoning of hard objects, as well as a sharp snap. The volume of footsteps were loud at first, but fades away. This suggests that an individual was rapidly moving away from the recording position.
Officer, what happened afterwards?
I later received a call from Wölff claiming that she had held a known criminal. Upon arrival, we found Ashlock disheveled, bruised, and seated in Wölff's basement. After her retrieval, we conducted a medical report on her injuries.
Officer, is conducting medical reports a regularly conducted activity at the police department?
As an officer, we have the duty to escort our found and notably damaged physically. We will be escorting them to the hospital and then taking them for a medical report checkup.
And will this report also be restored in the police department?
Certainly, it will be retrieved from the hospital and then be safe kept inside our storage.
Your Honor, let the record reflect that we're now screen sharing what has been pre-marked as Exhibit 9. Sir, do you recognize this exhibit?
Yes,
Is this a fair and accurate copy?
it is.
Has it been altered anyway since you last saw it?
No.
Your Honor, prosecution moves to enter Exhibit 9 into evidence.
Any objections to 9?
Yes, Your Honor. Rule 802 hearsay.
Response?
Response, Your Honor. This again goes towards the regularly conducted activity as an hearsay exception, and we would like to list why does it fulfill the 5 requirements of this exception if the defense counsel wishes to.
Response, Your Honor.
Yeah, let's hear a response from the defense.
Your Honor, our only issue with this document being admitted under Rule 8036 is prong D, the certification.
Okay, so defense, you're taking issue with people like proper custodian of the document, I'm assuming?
Yes, Your Honor.
Okay, prosecution response?
Your Honor, I believe that it was written at the bottom of this exhibit that there's a custodian, Dr. Allison Chang, who signed this medical report.
Response, Your Honor.
Briefly.
Your Honor, under prong D, a certification must meet the requirements of Rule 902.11 in order to be used during trial for 8036. Your Honor, unfortunately, during meet and confer with opposing counsel, we never got that sort of 902.11 notice. Therefore, Your Honor, procedurally, prong D doesn't apply.
Defense, isn't it stipulated that it meets 902.11?
Your Honor, it's our understanding that it's stipulated that it can be met. However, we would contend that we still need that notice.
Your Honor, I'm a bit confused in here. So is this like a prior offer notice or is this like stipulated?
Your Honor, I'm happy to clarify.
Yeah, you can clarify that.
Yes, Your Honor, under the stipulations, we stipulated that Dr. Allison Chen is a qualified custodian and she's able to provide the certification. However, Your Honor, we would still contend that just because she's qualified, that doesn't mean opposing counsel shouldn't give us notice beforehand as towards the certification and their use of it.
Okay, I see the issue here. You're saying that 902.11, I think A, hasn't been met because they haven't provided notice of using this exhibit.
That's correct, Your Honor.
Okay, this is very technical territory. I'm going to let it in just because the custodian has been stipulated too.
Yes, Your Honor.
Yes, Your Honor.
So overruled.
Officer, let's move on. What does this medical report show?
There are notably rope burns on the wrist and contusions to the right fist of Cotter Ashlock.
Officer, let's move on. Did you find any other notable evidence at the scene?
We did. At the scene, we found physical evidence of red residue, broken rope, a damaged chair, as well as other objects. Breaking the chair would create crashing sounds that mimics the noises from Wölff's call.
What does all your collected evidence suggest?
The physical evidence aligns with Cotter Ashlock's found state, such as finding broken rope in the basement and rope burns on her. It is a possibility that the crashing noise was Cotter Ashlock struggling on the chair, bashing it down, breaking rope restraints, and then fleeing.
Finally, officer, what were the conclusions that you made?
If all are true, then Cotter Ashlock was in Wölff's basement at the time of our first call. This means that Cotter Ashlock has been confined and has undergone physical conflicts in the defendant's basement before the time of the defendant's claim.
Officer, I want to make this extra clear to the members of the jury. When you called the defendant, where was Cotter Ashlock?
When I made my first call at 10:50, Cotter Ashlock was already confined in the defendant's basement.
Thank you, officer. No further questions, Your Honor.
Okay, cross-examination.
Yes, Your Honor, may I proceed?
You may.
Hello, Officer Capolino.
Hello.
A moment ago, you walked us through this three-step method you had, right?
I did.
It was the connect, the collect, and the conclude, right?
It was.
Let's walk down those three things and see whether or not your story makes sense. First step was connect, true?
That is true.
Let's connect the dots and see if Cotter Ashlock had a reason to commit a crime. You mentioned a moment ago, Investigator Wölff has been pursuing the Ashlocks for years,
I did.
giving tips about safe houses to the police, right?
She did.
Helping your police department catch those criminals.
She did.
Criminals like Cotter Ashlock, right?
Certainly.
Now, a moment ago, you told the members of the jury that Investigator Wölff didn't tell you that she had Cotter Ashlock in her basement, right?
That is true.
You said that she omitted information from you.
Sorry, could you go again?
No worries, sir. You said that, she kept information from you, correct?
That is true.
At this time, Your Honor, we bring the court's attention to case law State versus the Foundation for Poisoning Pigeons in 2025. False statements to law enforcement only constitute an interference charge if these statements harm the police's ability to perform a task. The exact wording's on screen. Sir, it's true that a week before Cotter Ashlock was captured, your police department got a call.
Could you go in 1 week ago? Sorry.
A week before Cotter Ashlock was in Investigator Wölff's basement, your police department got a call, right?
That is true.
You were notified that Cotter Ashlock had broken his parole,
Yes, she did.
that she could have just been roaming the streets.
She could have.
And for a week straight, your police department just couldn't figure out where she was.
That is true.
But then, Investigator Wölff, she was the one who turned Cotter Ashlock into your department, true?
We found her at the basement. We could not sure that, well, yes, she was found in her basement.
She wasn't just found in Investigator Wölff's basement. Investigator Wölff was the person who called you, right?
Yes, on our second call.
So we can agree, sir. Investigator Wölff helped you catch that criminal.
She did.
Moving on, sir. The second step in your method, that was collect, right?
That is true.
And in that step, you showed us this transcript, right?
We did, yes.
But you didn't show the members of the jury any physical evidence?
Sorry, physical evidence?
Yes, sir. You didn't show the members of the jury any physical evidence a moment ago, did you?
I have mentioned that we have found certain objects. It was not shown on photo, but yes, we found certain objects.
I'd like to delve a little bit more into those certain objects you collected. Because a moment ago, you told the members of the jury Ashlock was getting threatened, right?
Did I say? Sorry, could you say that again? I'm sorry.
No worries, officer. A moment ago, you told the members of the jury Cotter Ashlock was being threatened.
I did not say exactly that she was being threatened.
Well, that's what she told you, though, right, sir?
Yes, she told me so.
She told you that she was being threatened with this knife.
Yes, she did tell me that.
A knife that belonged to Investigator Wölff. That's her words, right?
That is true.
But a moment ago, you didn't show us a forensic report either, did you?
We didn't.
Sir, I'd like to show it to you right now, and we can talk about why you chose not to show the members of the jury that forensic report. Stating for the record, Your Honor, defense will be screen sharing Exhibit 11. Sir, this is that forensic report, right?
It is.
You'd agree with me, as an expert in police investigation and the lead investigator in this case, keeping forensic documents, that's a regularly conducted activity.
It is a regularly conducted activity.
And this record right there, there's a case number right there, right?
There is.
It was kept in the course of that regularly conducted activity, true?
Sorry? Kept in the court?
No, sir. This record, it was kept in the forensic department at your police station, right?
That is true.
And it's regularly kept in that course of business.
It is.
Your Honor, at this time, defense moves to enter Exhibit 11.
Any objections to 11?
None, Your Honor.
Okay, it's in.
Sir, if you look right there, this report looked at DNA and fingerprints, right?
It did.
I'm looking for a number here, sir. How many fingerprints of Investigator Wölff did your police department find?
None were found on these objects.
On the other hand, the only fingerprints you ever found were of Cotter Ashlock, right?
They were, but it is still a possibility that temporary gloves were worn. We cannot be absolutely certain that no other individual has touched these props.
Sir, it's your sworn testimony today there were gloves involved in this incident?
Could you go again?
No worries, sir. You just told the members of the jury someone could have been wearing gloves. Is that what you just said?
It is a possibility.
Sir, is that your sworn testimony?
It is.
Sir, you remember writing an affidavit before coming into court today?
I remember.
In that affidavit, you were truthful.
Definitely.
Your Honor, at this time, we ask for permission to screen share Larry Capolino's affidavit.
Granted.
Officer Capolino, this is your affidavit, right?
It is.
If we scroll down, that's your signature.
It is.
You were given up until opening statements today to change this affidavit,
That is true.
and you chose not to.
Indeed.
Sir, nowhere in this document do you ever mention the word gloves, right?
I didn't.
Thank you, sir. Thank you, Tech. We can take that down. Lastly, sir, I want to talk about what else you got wrong, just like the glove situation. Because in this case, you would agree with me, you don't have a lot of evidence.
I would say that we have found certain evidence, and I have stated them previously.
But sir, you only spoke to 2 witnesses, right?
Yes?
You didn't speak to any eyewitnesses?
No.
You didn't speak to any bystanders?
No.
You can't tell us whether or not Cotter Ashlock wanted Investigator Wölff dead.
Sorry, please go again.
No
I'm
worries,
really
sir.
sorry.
No worries, sir. I hope you feel better, but in the meantime, because you didn't speak to any other witnesses, you can't tell us whether or not Cotter Ashlock wanted Investigator Wölff dead.
No.
Thank you, Officer Capolino. I hope you have a good day. No further questions.
Okay, any redirect?
None, Your Honor. May my witness be excused?
Yes, he may step down.
Yes, Your Honor.
Prosecution, you may call your next witness when you're ready.
Yes, Your Honor. The prosecution would like to. Sorry, Your Honor. The prosecution would like to call Miss Cotter Ashlock to the stand.
Okay, you may proceed when you're ready.
Good evening, ma'am. Can you introduce yourself to the members of the jury?
Of course. Good evening. My name is Cotter Ashlock.
What do you do for a living?
Well, it's complicated. I'm sort of unemployed for now, as I was just released from prison.
So, what have you been doing since your release from prison?
I've been trying to rebuild my life. I volunteer part-time at the community center, helping with maintenance and supporting youth programs. It's not glamorous, but it's honest. It keeps my mind focused on something positive.
Can you tell us a bit more about your background?
Sure. I come from a notorious criminal family, the Ashlocks. I was born into it, and for a long time, I was a part of it. It was the only life I knew. Being the least favorite out of the three siblings, I wanted to impress my father my whole entire life, although I was mostly unsuccessful.
What happened in your past?
Well, I was convicted for my entire life. Extortion, counterfeiting, and I was an accomplice for murder. I served 5 years in prison for them. Prison was really a wake-up call. I really took that time to reflect and to really understand the pain I've caused. And when I was granted parole, I swore to myself that I would never, ever go back.
Ma'am, you said you're on parole. Can you tell us a bit more about it?
Sure, I had to live in New Hermitage, report regularly, and I was forbidden from entering Corleone or contacting anyone from my old criminal life.
Let me take you back to today's case. Can you tell us why you're here today?
I was kidnapped, then hurt in a basement on March 11th by the defendant, Nova Wölff.
Ma'am, why were you in Corleone on March 11th?
It was a terrible mistake. I heard a rumor that a family member who testified against us, Jaden Ashlock, might be in the area. And those old feelings of betrayal and anger flared up. I just wanted to see him and talk to him. I knew it was incredibly foolish.
Let's talk about your connection to the defendant. Do you know the defendant personally?
Yes, I do.
How do you know the defendant?
Well, Wolf had been haunting us for years. Since 2020. It's been 6 years. 6 years of hell. Mark Volkovic, Wolf's best friend, was poisoned by my cousin, Jaden Ashlock. Jaden's the one who later testified against us.
And after that?
Well, ever since Mark died, we have never been at peace.
What do you mean by that, miss?
She threatened us for years, constantly. I couldn't escape her, even when I was in prison.
Objection. As to lack of foundation, may I be heard?
You may.
Your Honor, the witness just stated that Miss Wölff had threatened her multiple times in the past. However, they failed to lay the foundation as to any of these specific threats. Whether it was an email, a letter, her showing up at her front door with a knife, there has been no foundation laid. And we're asking that it's laid because it's our contention today that all those threats were actually fake threats, not sent by Investigator Wölff.
Response, Your Honor?
Yes.
Your Honor, we're going to lay foundation, right? In our next question.
I'm going to overrule. I don't think we need the specific foundation of what the threats were. You can take it up on cross.
Our plan, exactly.
Miss Ashlock, let me take you back to my question. How did they threaten you?
The emails. They started in 2020, maybe earlier, and every single day at midnight, an email would appear in our family's address with always the same subject line, always watching.
Let the record reflect that we're now screen sharing Exhibit 12B. This has already been pre-entered. Ma'am, do you recognize this exhibit?
Yes.
Is it a fair and accurate copy?
Yes.
Has it been altered in any way since you've last seen it?
No.
Let the record reflect that we're now sharing 12B. Was this the email address that sent the threatening emails?
Yes. That's the one from mthewolf@gmail.com. She sent pictures of us. Pictures of us doing things. Illegal things, yes, but also just living. Walking down a street, eating at a restaurant, sitting in a car. Things you do when you think no one is watching.
I'm so sorry you had to experience that, ma'am. What happened after you received those emails?
I couldn't sleep for weeks. I started to keep my lights on all the time. I was terrified. I knew that no matter where I went, she would always find me. And she did. Look what happened on March 11th. She found me.
Now let's talk about the evening of March 11th. What happened?
I was walking down a street in Corleone, feeling sick with guilt about being there. It was pretty late, around 10:30 p.m.
Was anyone else on the street with you?
Yes, I noticed someone ahead of me, an old lady, maybe about 5 feet in front.
Did you notice anything unusual about her?
She kept looking around and behind at me, like she was afraid of something or someone.
What did she do?
She crossed the street and went into a house while she was still eyeing me.
And what did you do?
I didn't follow her. I just wanted to get into my car and leave. Then, from behind, I was suddenly struck in the back of my head. Everything went black.
And what happened after you woke up?
I woke up in a dark, cold room. A basement, I supposed. My hands were tied behind a chair with rope, and my mouth was taped completely shut. I was disoriented, terrified, and I desperately tried to break free. Then, Nova Wölff walked in while wearing gloves.
What did Wolf do after she came into the basement?
She ripped off the tape on my mouth and she started interrogating me. Not about my parole violation, but about Jaden Ashlock or Jay Kuang. Where is he? Where is Jay? She was frantic. I told her I didn't know. Jay was in witness protection. I hadn't seen him in years. Wolf said she didn't believe me.
For the record reflect that we're now screen sharing Exhibit 2. This has already been pre-admitted as evidence. Ma'am, do you recognize this exhibit?
Yes.
Is it a fair and accurate copy?
Yes.
Has it been altered in any way?
No.
Can you tell me about this recording?
Sure. Um, I was trying to secretly record the interrogation on my phone. That's where this recording comes from.
So did Wolf threaten you?
Yes. She said she was very persuasive with criminals. She said that if I walked out of the door, I'd walk straight into the police. But I was tied up. I couldn't walk anywhere. She also had a knife. She picked it up from the table and waved it while she questioned me.
How did this recording end?
Well, Wolf saw me doing the recording, and she got furious, grabbed it from my hand, and smashed it on the wall.
What happened next?
There was a struggle, but I managed to get my hands free from the chair. Then I ran out of the basement, out the front door, and then finally had a taste of fresh air.
So did you escape?
No, I mean, I thought I had, but then Wolf came to the doorway and just stood there. She said, she said that if I ran, she would tell the police that I'd attacked her, that I had a knife. She said it would be my word against hers. And who would believe in Ashlock? I felt trapped, and I made the worst decision of my life. I went back inside.
Back inside? What happened, ma'am?
I tried to explain to her that it would have been hell if the police knew about my parole violation. I had just started rebuilding my life and would soon be in shambles. Soon, it escalated. Wolf was fuming as she used her knife to try to attack me.
What did you do?
I just tried to defend myself, to block her attacks. But I won't lie to you, ma'am. At some point, her knife ended up in my hand. But I didn't try to use it to attack them. I was just trying to defend myself, to block her attacks, to stop her from hurting me. I was just trying to survive.
What happened at the end of the fight?
Eventually, Wolf overpowered me and tied me back to the chair. Then I heard him talking to someone, and the next thing I knew, the police were there.
No further questions, Your Honor.
Okay. Cross-examination.
Yes, Your Honor. Hello, Miss Wölff.
Hello.
You've been here throughout today's trial, correct?
Yes, that's true.
Earlier today, you heard your attorneys make a promise.
Which promise?
You heard your attorney promise in opening statements that the jury will find your account is corroborated by evidence.
Yes.
Let's see whether or not the evidence shows any inconsistencies in your story. Stating for the record, will now be screen sharing Exhibit 2, which per stipulation has been pre-admitted. Now, ma'am, I couldn't help but notice you read this email to the members of the jury a moment ago, correct?
Email?
Or rather, this recording.
Yes.
Ma'am, you read specific parts of it. You didn't read the whole thing.
Yes, that's true.
So I want to pick up where you left off and see if you missed anything. Because in this recording, she never says you were caged against your will.
No, but the recording was only a part of our conversation.
Even if it was a small part, this small part, it says you're no one's prisoner.
Yes, that's true.
Now, nowhere in this transcript does she threaten any physical violence against you if you left.
No.
She actually told you that if you walked out of those doors, you'd be walking into the police's hands.
Yes.
Moving on, let's see if there's any evidence supporting your claims about being attacked. A moment ago, you claimed that she was wearing gloves when holding that knife.
Yes, that's true.
Ma'am, you're the only one who's saying that on stand today, aren't you?
Well, I was the only one who was actually there on the scene, so.
So that's a yes to my question. You're the only one who's saying she had gloves on.
Yes.
Because you heard the investigator say a moment ago, and I quote, "I never included finding gloves in my report."
Yes, I believe so.
I want to talk about something that may not be inconsistent. Because in this forensic report you mentioned a moment ago, it states that the only DNA found on that knife was yours.
Yes, that's true.
All right, ma'am. I want to see whether there are any other inconsistencies in your testimony with that email. Now, a moment ago, you brought up that email saying that Investigator Wölff was threatening you.
Yes, she was.
I want to paint a picture for the members of the jury. Stating for the record, my colleague Miss Liu will now be screen sharing an email inbox. What you see on screen is an email inbox, correct?
Yes.
And as of right now, you see that there's an email draft.
I do see that.
Written there are threats.
Yes.
The same threats on the email you just showed us.
Yes.
Now, Miss Liu is going to send this email to me. Now, if we go to sent, ma'am, you can see that the sender says N. Wölff, correct?
Yes.
But, ma'am, you've been here all of trial, haven't you?
I have.
You saw my friend Miss Liu.
Yeah, I did.
Miss Liu isn't Investigator Wölff, is she?
No, she isn't.
So, in other words, she just wrote a fake email, and there was nothing stopping her.
Yes.
I want to talk about whether or not you would have a motive to potentially write that email. Because it's true that Investigator Wölff, well, she's kept tabs on your entire crime family.
Yeah.
Ma'am, can you say yes or no for the court?
Yes. Sorry, I have some internet connection issues.
I understand, ma'am. Now, it's true that she didn't just keep tabs on you for a short period of time. It spanned over years.
Yes, 6 years to be exact.
You'd say she made your job harder than it should have been.
Yes.
Consistently tracking your whereabouts.
Yeah.
She was even working with the police to catch your family.
Yes.
She even helped the police catch you.
Yeah.
And after she helped the police catch you, you went to jail for years.
Yeah. But it really helped me change my perspective on things. I've come out as a new woman.
All right, ma'am. We'll let the members of the jury decide that. Your Honor, at this time, I have no further questions.
Okay. Any redirect for this witness?
None, Your Honor. May my witness be excused?
Yes, Miss Ashlock, you may step down. And at this time, we'll take a 5-minute break and then come back for defense case in chief.
Excellent. We'll be right back.
Thank you, Your Honor.
Okay, we should all be coming back.
Your Honor, the defense is here and we're ready to go.
Okay, prosecution.
Yes, the prosecution is also ready to proceed.
Sounds good. In that case, defense, call your first witness.
Yes, Your Honor, at this time we call Charlene Reeves to the stand. May I proceed?
You may.
Good morning, ma'am.
Hello.
Could you please introduce yourself to the folks on the jury?
Sure, I could. Hi, everybody. My name is Charlene Reeves.
Miss Reeves, where are you from?
Well, a long time ago, I grew up in Tilly, but I always like to say that my real home is New York City.
Why do you say that?
I used to work as a taxi driver there. You know, I never picked up an accent. All I can say is, I'm walking here. But anyway, I picked up more playbills than I did passengers.
What do you mean?
Well, the best part about living in New York City is getting to see all the shows on Broadway. You know, nowadays with all these gray hairs, watching musicals at the local high school with my neighbor is much more my speed.
Who's your neighbor, Miss Reeves?
Nova Wölff, her family and I are cut from that same musical loving cloth.
And do you understand why you're here today?
You bet I do. I was there the night that Nova was attacked by a criminal, and I'm here to talk about it.
All right, then, let's talk about whether that criminal had a motive to harm her. To your knowledge, do you know Miss Wolf's occupation?
I do. When she isn't disciplining her little kiddos, I help babysit them while she disciplines criminals as a private investigator. That's our little joke. I like to call her my little investigator.
Why do you call her your little investigator?
Well, you know, us ladies have the gift of the gab. You know, we have over homemade cookies and afternoon tea. She always chit-chats about our town and even about these criminals. They're called the Ashlocks.
And during these chats, did Investigator Wolf ever tell you anything about her history with the Ashlocks?
Yes, she told me that since her close friend was poisoned by the Ashlocks, she's been helping the police catch them for years.
How?
She said she would, you know, give tips to an officer and she reports all kinds of suspicious activity and she even helped put some of the Ashlocks behind bars.
Moving along, let's talk about when that criminal attacked her. What were you doing earlier that evening?
Well, I was at our senior center. We were practicing for our production of Annie. Just think less hard knock hips and or less hard knock lives and more hard knock hips. Around 10:30 after that, I started heading home.
Stating for the record, we'll now be screen sharing a visual aid of events. Ma'am, after around 10:30, did anything out of the ordinary happen?
Well, at first I was walking home just humming some show tunes, but then I turned this corner and I realized that someone was following me.
What did you do?
I mean, I was really scared. I didn't know if that person was trying to follow me, stalking me, or if they were just loitering.
So, what happened next?
Well, thankfully, I wasn't too far from my little investigator's house to ask her for help, so I was frantically knocking on her door.
Did she answer?
Eventually, she opened the door and, I told her what was wrong, and she shut the door and told me to go back inside because she would take care of it for me.
Did she end up taking care of it for you?
Yeah, she did. That's when I could tell that things were serious. Just a few minutes later, I heard someone belt out at the top of their lungs the name Ashlock.
What did you do?
I mean, I pulled out my spectacles. Hold on. They're these ones. They're gold like Galinda's hair, so they gave me a little bit of comfort. But then I peeked out my window and I saw Cotter Ashlock. She has this long black hair, glasses. She was dressed in a dark black color, and she ran out of Nova's doors.
Objection, Your Honor. Lack of foundation.
Could you explain?
Yes, Your Honor. Your Honor, they didn't clarify how she knew her. She only heard of her from Nova Wölff. And specifically, how did Miss Reeves recognize her face?
I see. Response defense?
Your Honor, we're currently in the process of laying that foundation. As my previous question was, what happened next? I'm still at the beginning portion of laying that foundation.
I'm going to sustain. I need you to lay that foundation before this comes up on the timeline for the jury.
Absolutely. Your Honor, constructively, can we redact that portion until that foundation is laid?
Yes.
Now, ma'am, I want to get something clear. I understand you know musicals, but how do you know what Cotter Ashlock looks like?
Well, I know the Ashlocks from Nova, and a couple days before this whole thing happened, Cotter Ashlock was released on parole, and it was on the news. I knew who Cotter Ashlock was.
And did you see the same woman who was on the news leave Investigator Wolf's house?
Yes, that's the same person I saw run out.
So during this time of Cotter Ashlock leaving the house and you seeing Investigator Wolf, did you end up figuring out if she was ever wearing gloves at this time?
No, I never saw Nova wearing any gloves.
Did you ever see her try to block the Ashlock from leaving?
No, she was just standing there. Then it looked like she had run back inside, and I heard a pained yell from Nova saying, you have a knife?
Did you hear anything else?
The next thing I heard was Nova commanding her real seriously to stop and let go.
Did you hear anything else after you heard the saying, "You have a knife," and "Stop, let go"?
I heard sirens. It was music to my ears. It meant the police were coming and the scariest night of my life was coming to an end, and that Nova and her kiddos would all be safe.
I appreciate your time, Miss Reeves. Your Honor, at this time, I have no further questions.
Okay, cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good day, Miss Reeves.
Hello, darling.
I want to start off by talking about your relationship with the defendant. You called the defendant your little investigator.
Yes, that's my nickname for her.
And ma'am, you see Nova as your grandkid.
That's right.
You said you'd never forgive yourself if something happened to Nova.
That's right. I wouldn't want her kiddos to lose her or anything bad to happen to her.
So you care about Nova, don't you?
Of course I do.
Miss Reeves, you grew close with the defendant, didn't you?
Yes.
You said she chit-chats a lot about the Ashlocks, correct?
Yes, when she's over tea, she tells us about our town and yeah, the Ashlocks.
Her close friend was poisoned by them.
Yes, that's what happened.
She's been tracing down the Ashlocks since?
Yes, she's been trying to help catch them after that.
And you know the defendant moved here for revenge, don't you?
I do. That's what she told me.
Ma'am, let's move on to the day of the incident. On March 11th, you said you heard someone following you?
Yes.
You said you weren't sure about what they were doing.
No, I couldn't really see anything. I didn't know what they were doing there. Yes.
You did not recognize them?
Not right away. It was dark in that part.
So you did not see their face.
Not at that time, but later I did see.
Is that a yes to my question?
It's a yes, not at that time.
But you later said it was Ashlock, even though you didn't see their face at that time?
I didn't see their face at first. It was dark and I couldn't, it was too dark for me to see. But when they ran out of Nova's house, they were in the street light and I could see that it was Cotter Ashlock.
Ma'am, you observed everything from your window when you
Yes.
went back to your house. You weren't in Noah's house.
No, I wasn't in the room where it happened.
You weren't outside near her house?
No, I stayed on my property.
Ma'am, you're not present at the scene at all.
Not to see. I could hear from my house though.
So your testimony is all based on what you heard, correct?
That's exactly right, ma'am.
That's all.
Okay. Any redirect?
No, Your Honor, I don't believe that's necessary now. My apologies. May Miss Reeves step down?
Yes, she may. Miss Reeves, you're excused. And defense, when you're ready, call your next witness.
My apologies, Your Honor. I was experiencing some difficulties with my mic.
All
At
good.
this time, at this time, we call investigator Nova Wölff.
Okay. You may proceed when you're ready.
Yes, Your Honor. Hello.
Good morning.
Please introduce yourself to the members of the jury.
Hey everyone, I'm Nova Wölff.
Investigator Wölff, do you understand you have a constitutional right not to testify?
I do. I've been told that many times, but look, I need to set the record straight.
Understood, Investigator Wölff. But before we get on to what Miss Fang's been saying, can you tell the members of the jury a little bit more about yourself?
Of course, I'm a private investigator, PI, and when I'm not working, I'm probably spending time with my two kids. I've got a 13-year-old and a 7-year-old at home.
How'd you get into that line of work?
Growing up, my papa used to tell me that there were three kinds of people in this world. You've got the bullies, the bullied, and the protectors. And I wasn't big enough to bully anyone, and I was too stubborn to be bullied, so I've always wanted to protect people.
How are you qualified to protect people?
Well, I like to say that my first real training was growing up with three older brothers. But professionally, I earned my credentials in criminal science, criminal justice. I completed 6,000 hours of compensative investigation experience, and I obtained my private investigator's license. It's been 22 years now of doing my best to protect my community.
Is there anything you protect your community from?
There's this family in the town that I live, better known as a crime syndicate. They're infamous for all sorts of crimes: homicide, extortion, poisoning, things like that.
Poisoning, ma'am?
Yes, they actually poisoned one of my friends, Mark, 5 years ago.
On that note, ma'am, I'd like to address what the state's been saying today. After the Ashlocks poisoned your friend, did you choose to cage over calm?
No, absolutely not.
What did you choose instead?
I chose to honor Mark. He always used to tell me, when people are safe, our jobs are done. And I would never cage someone for personal vengeance. That's just not what I do. And and that's not what Mark would have wanted either.
Investigator Wölff, how did you want to honor your friend?
I guess by protecting as many people as possible, by making sure what happened to him never happens to another person, not on my watch. That's my job, and that's why I performed a citizen's arrest on Cotter Ashlock.
Let's walk through how you performed a citizen's arrest on Cotter Ashlock. When did you first see her?
That night, it was a little after 10:30 p.m. After I'd put my kids to bed, my next door neighbor, Mrs. Reeves, she knocked on my door and she told me that someone had been following her.
What'd you do after that?
I walked out of my house. I wanted to evaluate the situation. I was just expecting someone who wanted money or someone drunk outside, but I that's not what happened at all.
Who did you see instead?
I saw Cotter Ashlock.
How did you react?
Well, first I was shocked, and then I was really worried for myself, for my kids sleeping inside, my neighbor who lives alone, the people living around us. I know who Cotter Ashlock is. I knew who I was looking at.
Ma'am, what do you mean you knew who you were looking at?
I'm a private investigator. I I know the things Cotter Ashlock has done. I mean, I helped document evidence to send her to prison. I knew she was on parole, but I could have never imagined that this criminal was out on the streets, on my street. She was supposed to be far away.
Investigator, why do you say the word criminal?
Cotter Ashlock was given a second chance. She was on parole, and she broke it to wander in front of my house, to trespass on my neighbor's property from my work. I know that's violating parole. That's a felony.
What did you do after you witnessed that criminal commit a felony?
I confronted her. I told her I was going to call the police, and I instructed her to leave my town.
How did she respond?
I remembered she took off these black framed glasses she had, put them in her pocket. She was shouting at me, and then she reached into the left side of her jacket and she pulled out this giant knife, and then she lunged towards me with it.
What did you do once that criminal lunged towards you with that knife?
Oh, I disarmed her. I kicked the knife out of her hands, and then it fell on the sidewalk, and I restrained her, and I took her to my basement.
Today, the state said that you threatened her with a knife. Is that true?
Not at all. I kicked it away as soon as I saw it. I didn't want something like that near my home, near my children. I planned on taking her to my basement, calling the police. That was it.
I want to make this really clear for the members of the jury. Did you ever use that knife?
No, I never touched it.
Were you ever wearing gloves?
No. I heard I heard Cotter say that a few moments ago, but that's not true. I never had gloves on during that night.
Did you speak to Cotter Ashlock as she was in your basement?
Yes, we had a brief conversation the first time right after I restrained her.
Stating for the record, Your Honor, we'll be screen sharing Exhibit 2, which is already in evidence pursuant to Stipulation 7. Ma'am, is this a transcript of that conversation?
It is.
Today, the state alleges that you held Cotter Ashlock in your basement against her will. Do you agree?
No. Once she was in my basement, I was prepared to call the police, and I figured my job was done. I mean, I told her you're no one's prisoner. And that was true because she left momentarily after.
Oh, hold on, ma'am. She left?
That's right. She walked out of my basement. I followed her to my doorway just to make sure she didn't do anything rash near my kids. And she left.
What did you see as you followed her to the doorway?
I saw her walk out my door. She was walking to the sidewalk, and we were near where we were earlier. And then she bent over, and then she picked up something.
Did you see what she picked up?
It was the knife that I'd kicked out of her hands earlier. She put it back in her jacket, and then she just charged back towards me.
What did you do after she charged back towards you with that knife?
At that moment, all I could think about was that my front door was open. My kids were inside. So I decided to restrain her. I figured this time my job was done. So I tied her up and we waited for the police to arrive.
Let's talk about whether or not you acted reasonably as you were doing your job. In opening statements, did you hear Miss Fang say that all you had to do was call 911?
I did hear that, and that's what I did.
How long did it take you to call 911?
I think about an hour.
Why did it take an hour?
Well, trust me, I didn't want it to be that way. But Ashlock was she was struggling against me, and I was afraid she was going to do something to my kids. So once she was calmed down, and once I determined that my kids were going to be okay, that's when I called the police department as soon as I could.
As she was struggling against you, ma'am, did you ever use violence on her?
The only thing I did was restrain her, tie her up. I only did what was necessary in order for her to stop lunging at me with a knife. And then we waited for the police.
At this time, Your Honor, we'd like to bring the court's attention to case law Center for Academic Integrity versus Lobachevsky, 1955. Reasonable force, in determining whether an action constitutes a citizen's arrest, is defined as the force that's necessary to prevent the escape of the arrested. Investigator Wolf, I want to make this absolutely clear. Did you ever exert force on Cotter Ashlock that you didn't deem necessary?
Absolutely not. I was protecting my neighborhood, and when she tried to attack me, I acted in self-defense. As private investigators, we always err on the side of caution, and I was careful not to do anything that was unnecessary. I would only do anything to protect my community and protect the people I love. But now I don't know anymore.
Why don't you know anymore?
Well, look at me. I might go to prison. Cotter Ashlock still roaming the streets with my kids near my home. It's the first time I ever failed at my job.
Thank you, Investigator Wolf. Your Honor, at this time, no further questions.
Okay. Cross-examination.
Yes, Your Honor. Good morning, Miss Wolf.
Good morning.
Let's start off with some backstory. So you mentioned that you're quite familiar with the Ashlock family, yes?
I am.
And you know that the family is a menace in the region.
Absolutely.
In fact, you have investigated them, right?
That's right.
But ma'am, you don't work with law enforcement.
No, I'm a private investigator.
So after all, you're just a civilian, yes?
That's right. I'm not a police officer.
Yes, ma'am. Let the record reflect Exhibit 12B. This has been pre-entered. Miss Wolf, did you send this email?
No, No, I've never seen this email before. I did not send this.
All right, we'll take your words for now. So let's take a closer look at this email. You can see that this writer called himself the best friend of the man you murdered.
That's what it says?
And interestingly, Miss Wolf, the Ashlocks also killed your best friend.
They did. They poisoned my friend Mark a couple of years ago.
How'd you feel at that time?
I was extremely sad, angry, I guess. It made me want to protect my community even more.
I think the prosecution may be frozen, so we'll pause time to account for it.
Yes, Your Honor.
My apologies, Your Honor. Our school's Wi-Fi just died, so but now we're good.
No worries.
Ma'am, let me bring you back to my question. How'd you feel when your friend was murdered?
I was sad and I was angry, but more than that, it made me want to protect my community even more.
Exactly, ma'am. You were angry at that time.
Of course I was.
So you did hate the Ashlock.
I guess you could say that.
Ma'am, let's look further into the last sentence in this email. The last sentence wrote that I will tie you up and torture you until you beg me to kill you. Did I read that correctly?
Objection, Your Honor. 403, more prejudicial than probative, if I may be heard.
You may.
Yes, Your Honor. Throughout this entire trial, the defense has contended that this email was in no way, shape, or form authored by Investigator Wölff. Ms. Garcia has proven the feasibility of a made-up email through her cross-examination. Ms. Wölff has repeatedly denied authoring this email, and Your Honor, opposing counsel reading lines of this email onto the record is going to prejudice the jury in a way that isn't admissible.
Brief
Response, Your Honor?
response. Yes.
Yes, Your Honor. We believe that this is way more probative because this again goes to the motive of the defendant. And as for the defendant has not yet admitted that this email was written by her, that should be left for the members of the juries to decide because we have a lot of evidences on this email that points towards the author of this email was defendant.
Response, Your Honor?
No need. I'm gonna overrule. It's pre-admitted already. I think this goes to whether or not she actually authored this email. I'm gonna let it stand.
Yes, Your Honor.
Your Honor. Ma'am, let me bring you back to my question. The last sentence wrote that I will tie you up and torture you until you beg me to kill you. Did I read that correctly?
That's what it says, but I never wrote this email. I've never seen this before.
I understand this, ma'am. So it is fair to say that this email is threatening the Ashlocks.
Whoever wrote this email clearly was.
Exactly, ma'am. So it is also fair to infer that this email writer hated the Ashlocks.
Sure.
And you just mentioned as well that you hated the Ashlocks.
I did, but that's right.
And you would also agree with me that you and this writer share pretty similar experiences.
Sure, but I never wanted to tie up and torture the Ashlocks until they begged me to kill them. That's insane.
Ma'am, my question was, did you and this writer share very similar experiences as your friend was murdered?
You could say that.
All right, ma'am. And you also shared a similar hatred toward the Ashlocks.
I used to, at least.
And most interestingly, it also says "and the wolf" at the top.
That's right. That's not my email though. I've never seen that before, but that's what it says.
Your words, ma'am. Let's leave it to the members of the jury to decide. All right, ma'am, let's move on to the day of the incident. So you just said that on March 11th, around 10:30 p.m., you noticed Cotter Ashlock in front of your house.
A little bit after 10:30, after my neighbor Mrs. Reeves had told me that someone was following her, that's when I saw Cotter.
So at that moment, were you in your house?
No, I was outside, I believe.
But the door was shut.
The door was sure. I was outside.
So your kids were protected inside your house.
No, I was scared for my kids' lives. The door might be shut, but who knows who could barge in there.
All right, ma'am. But you did admit that the door was shut, and you did not call the police after seeing Cotter Ashlock.
No, Cotter Ashlock was lunging at me with a knife. How was I supposed to call the police as I was actively being attacked? No, I didn't call the police right then and there.
Your words, ma'am. Then let's look at what happened afterwards of whether you have the chance of calling the police. So you said you took Cotter Ashlock into your house,
That's right.
and you said you restrained her.
Yes.
You restrained her fully to a chair.
Yes. I didn't want her lunging at me with another weapon or lunging at my kids. I restrained her to her chair.
So you would agree with me that at that time, Cotter Ashlock was not fighting nor struggling.
That's right. That's why I told her she was free to leave my house.
Ma'am, you know Cotter Ashlock was a lethal criminal.
I know. I'm very aware.
But after you confined her in your house, you then told her to leave the house?
Yes. I'd call the police. I figured that was a done job. I didn't want to keep her prisoner for an unnecessary amount of time.
Ma'am, you just said that you told Cotter Ashlock to leave your house, but you did not mention a word about you calling the police before that. Am I correct?
Hold on. I told her she was free to leave if she wanted to, but she came back
Exactly.
inside.
Sorry. Exactly, ma'am. So that was your own words that you are free to leave.
That's right.
Ma'am, at that time, Cotter Ashlock was restrained fully on a chair.
Well, she was untied when she got up and left.
But at that time, she was restrained fully.
Yes, because I had restrained her. Yes.
And at that time, you did not call the police.
No, I was planning to after she'd left and after I'd made sure my kids were safe.
Ma'am, I'm not asking about what you're planning. I'm asking that you didn't call the police at that moment.
At that moment, no.
Ma'am, you just said that it takes an hour to call the police.
I never said that.
Ma'am, I believe that you mentioned in your direct examination that it takes an hour to call the police.
It doesn't take an hour normally, but in that situation, it took me an hour to calm everyone down. That's what I meant.
Exactly, ma'am. In your direct examination, you mentioned that it was because Ashlock was fighting, and that was the reason that you called the police for an hour. Am I correct?
Yes, ma'am, that's right. But this was after I told her she was free to leave. She re-attacked me, and that's why I had to re-constrain her.
Ma'am, for the sake of the members of the jury, can you please just give me a yes or no to the question that you did not call the police?
Objection, Your Honor. At this time, it's asked and answered.
I'm going to overrule, but state one more question about this and then move on.
Yes,
Yes,
Your
Your
Honor.
Honor.
Ma'am, at that time, Cotter Ashlock was fully restrained as you just stated.
At that time, yes.
So it would not take you an hour to call the police.
That's not right.
Ma'am, you just said that it takes an hour to call the police, even when Cotter Ashlock was fully restrained?
Ma'am, I'm saying I had to make sure my kids were safe, the doors were locked, everyone was okay in my house before I could call the police.
Ma'am, you believe that doing all of those things are more important than arresting a criminal?
No, I think they're equally important. Just because I call the police while Cotter Ashlock is in my basement doesn't mean I can't also protect my children.
Ma'am, you know that such a criminal should be left for the police to handle.
You could say that.
But you still believe that the urgency of calming everybody down is equal to calling the police.
Absolutely.
Your words, ma'am. Ma'am, let's move on to what happened after 10:50 p.m. So you said that you had a conversation with Cotter Ashlock.
That's right.
And when you had that conversation, Cotter Ashlock was still restrained on the chair.
Yes.
And again, you did not call the police.
That's right.
Objection, Your Honor. At this point, I re-raise my objection.
Yeah, I'm gonna sustain. Move on.
Motion to strike.
Stricken.
Yes, Your Honor.
Yes, Your Honor. So, ma'am, at the second time of that restrained, Your Honor, I believe so. Let me clarify that I'm asking for the second time that the defendant has confined the criminal. Ma'am, on the second time of your confinement, Ashlock was still restrained on the chair.
She was.
And you did not call the police.
Not at that point, no.
But instead, you had a conversation.
Yes.
So you choose a conversation over a call with the police.
No, that's not what happened.
Ma'am, you just admitted that you had a conversation instead of call.
Well, we've been talking the whole time, but once she was in there, constrained to the chair after she tried to attack me again, I needed to make sure that there was no more rash actions she was going to commit before I called the police.
Ma'am, is that a yes to my question that Cotter Ashlock was constrained and you had a conversation?
Yes.
No further questions, Your Honor.
Okay. Any redirect?
Yes, Your Honor. Investigator Wolf, Miss Fang just went a lot about how you didn't call the police. Can you explain to the members of the jury exactly why you weren't able to do that?
I can't pick up the phone and call the police when there's someone threatening me in a chair, even if they're tied up, when they just had a knife in their jacket. That's not safe for my kids. It's not safe for me, frankly.
And taking a step back, ma'am, I want to touch on something Miss Fang brought up earlier. Did you see the email that she showed you?
I did.
I want to make this absolutely clear, ma'am. Did you send this email?
Absolutely not. Actually, in my line of work, I find that people love to create and plant fake evidence all the time. I don't know if this is what happened here, but that's not my email.
Understood, Investigator Wolf. Thank you so much for your time. Your Honor, at this time, no further questions.
Okay. Any recross?
Yes, Your Honor.
Okay.
Miss Wolf, dialing 911 is only 3 digits, right?
That's right.
And how many seconds do you think it would cause to dial these 3 digits?
A couple seconds if you're not in an emergency.
Exactly, ma'am. It was only a couple of seconds. But you've been waiting for an hour, right?
Wasn't waiting, ma'am. I was doing things to make sure my kids were protected, but it did end up taking me an hour.
Exactly, ma'am. It was an hour, but it only takes a few seconds to call the police.
Sure, if you're not being threatened actively and not concerned for your safety, it does take a few seconds to physically dial 911.
So that's a yes to my question.
Yes.
No further questions, Your Honor.
Okay, I don't believe there's any redirect in this jurisdiction, so Miss Wolf, you are excused.
Yes, Your Honor. And with that, defense rests our case in chief. Your Honor, the defense is back and ready to proceed.
Okay, prosecution. Okay, we'll take a brief moment and wait on them to come back.
Yes, Your Honor. Your Honor, we just had a bit of an internet issue, and we'll just fix that in a minute. My apologies.
No worries. Just let us know when you're ready.
Your Honor, my co-counsel is going to be using my camera as our school internet has went down, and prosecution ready to proceed.
Okay, in that case, prosecution, take it away.
Yes, Your Honor. May it please the court. Members of the jury, today you heard Miss Ashlock's story. A story of someone who did not get to choose. Someone who learned the hard way in jail that life does not move forward through violence. Someone trying to rebuild their life. And everything was going right when she was attacked. She woke up in a cold, dark basement, her hands tied to a chair and her mouth taped shut. Standing in front of her was the defendant. Angry, determined, and in control, members of the jury, the defense today kept emphasizing that Miss Ashlock was a criminal. That the defendant captured a crime, but members of the jury, the focus of this case is not on Miss Ashlock's past. It is on how the defendant captured Miss Ashlock. She locked her in a basement, she shut the door, and she pulled a knife. She chose a cage over a call. As a prosecution, we brought forward two charges. First, that the defendant unlawfully imprisoned Miss Ashlock, and the second, that the defendant interfered with law enforcement. Our burden is to prove that beyond a reasonable doubt, the defendant met this burden. And we have done that through three facts. The defendant wanted revenge, the defendant confined at knife point, and the defendant hid it from the police. Members of the jury, the defendant had a motive. They did not do it out of impulse, nor was it simply to help a neighbor. The moment she saw Cotter Ashlock, she started her plan that she had grown from a grudge. You heard Miss Ashlock today in trial. Days and nights the defendant tracked their family. She sent threatening emails, stalking photos of daily scenes. You saw the signature N. Wölff and the exact threatening phrases in the email. Members of the jury, what a coincidence. But why the Ashlocks? Because her friend was poisoned and killed by them. She had a grudge. She wanted revenge. Moreover, Miss Ashlock also told you exactly what happened. She was hit in the head and woke up in a basement. She faced confinement,
ropes, knives, and her freedom was constrained. She was controlled, her hands were tied, yet the defendant, she tried to threaten her. How? The defense wants you to believe that because Miss Ashlock walked back into the house, everything that followed was lawful. But what matters was what the defendant did. Members of the jury, you saw the phone records, the medical reports, forensic evidence confirmed that there was clearly not only restraint, but violence in that basement. A reasonable citizen's arrest does not allow you to imprison someone or to threaten someone, and it definitely does not allow you to build a jail in your basement. This is simply not a capture. She chose a cage over a call. And finally, Officer Capellino testified to you that he wanted the defendant to be told not to interfere, not to cross the border. Arresting a criminal was the law enforcement's responsibility. You heard in the cross the defendant was not a police officer. She was a citizen. But she simply ignored that instruction. Instead, she acted on what she wanted to do for a long, long time. She ignored the first call. And what about the second? She said nothing. She was unable to make a call. She wanted to protect her kids. 1 hour, members of the jury. She had 1 hour to dial 3 letters. Guilty people build narratives. Hiding only happens when someone knows they crossed the line. The defendant hid it from the police when she had a choice. The defense claims that she captured a criminal to stop a crime, but members of the jury, stopping a crime does not give you a right to commit one. It doesn't give you the right to threaten someone, attack someone, and illegally confine someone. She chased revenge. She confined at knife point. She hid it from the police. 3 facts, 3 choices that were all made by the defendant. Members of the jury, this trial is not about who Miss Ashlock used to be or what she had done. It is about what the defendant did. No matter who was in that basement, the law does not allow intentional confinement. It does not allow you to tie someone in their basement against their will and threaten them. It does not allow hiding from the police when a choice exists. On March 11th, the defendant had a choice, and she chose a cage over a call. Find the defendant guilty.
Thank you. Defense closing argument.
Yes, Your Honor. She captured a criminal to stop her crimes. The prosecution told you she chose a cage over being calm. Members of the jury, it's not a cage if Cotter Ashlock could have left. It's not a cage if she was free to go. And members of the jury, today you learned it wasn't Investigator Wölff who built that cage over calm. But instead, Investigator Wölff was forced to stop a crime. But if the prosecution wants to talk about choices, then let's talk about choices. Because when they chose to call Miss Wölff a criminal, when they chose to charge her with 2 felonies, when they chose to step into this courtroom today, they've assumed the highest burden in our legal system. It's called proof beyond a reasonable doubt. It means at the end of today's trial, if you have one reasonable question, one reasonable doubt that their side of the story might not be true, Miss Wölff isn't guilty. But folks, they haven't met that burden today. And we knew from the very start they weren't going to be able to, which is why we brought on an affirmative defense. Simply put, if we prove that it's more likely than not that Investigator Wölff witnessed a crime, used reasonable force in her capture, and contacted the police within reasonable time, she's not guilty. And we've proven that to you today through 3 facts. First, the crime. Today you learn Investigator Wölff witnessed a crime. No one's gonna dispute that. Because today you learn that Cotter Ashlock was on parole. She was on parole for decades of crime, and she was on parole because she was given a second chance. But instead of taking it, instead of rehabilitating like Miss Fang tried to tell you, she took that chance to get revenge. Today you learned Investigator Wölff was the reason Cotter Ashlock ended up behind bars. Investigator Wölff was the reason that the Ashlock family's crime syndicate wasn't so at large anymore. And you learned today that when Cotter Ashlock knew she had a chance to change that, she took that chance. She made that choice. She took a crime over being calm. Secondly, the capture. Did Investigator Wölff use reasonable force in detaining Cotter Ashlock? Because unlike what the state wants you to believe, under the law, Investigator Wölff doesn't need to be as gentle as possible. She doesn't need to wait until someone is bleeding out on the streets. She just needs to do what's reasonable. And today you learned that when she was held at knife point, when her kids, her neighbor, her community was being threatened, she did what was necessary. She didn't choose to cage anyone. She captured a criminal to stop her crimes. And folks, you don't have to take it from me. You don't have to just take it from Miss Garcia. You can take it from the state themselves. Because today, when they called their officer, they showed you this medical report. Said that Cotter Ashlock had signs of dehydration and rope burns, but members of the jury, what they didn't tell you, what they didn't want you to know, was that Cotter Ashlock was threatening Investigator Wölff. Threatening with a knife to the point where she was found with bruises all over her knuckle. And the state tried to tell you today, no, it was Nova Wölff who was threatening. It was Nova Wölff who pulled that knife. It was Nova Wölff who did all of that. And they even tried to tell you she was wearing gloves. Members of the jury, that's what Cotter Ashlock said. And Cotter Ashlock alone. Because today the state tried to get their officer to tell you, oh, there was gloves. But when you saw that affidavit pulled up, when you saw that he was confronted with the truth, when he was confronted with the penalty of perjury, it's his words verbatim. I never included the possibility of gloves in this report. Why? Because it doesn't exist. And so when the state wants to talk about calm, let's talk about calm. The only people that weren't calm today were the witnesses they called. And Officer Capolino, he tried to show you a medical exam, tried to show you a transcript, but he forgot to show you all the physical evidence there was, forgot to show you the forensic evidence there was. Why, members of the jury? Because that's bad for them. Because that report alone shows Nova Wölff had nothing to do with that knife. But then, Cotter Ashlock. Cotter Ashlock, today on the stand, she was nice, she was calm, she was friendly. She doesn't seem like someone who would choose a crime over being calm. But folks, I want you to compare her demeanor to you today to her demeanor to Nova Wölff. Her demeanor when she was holding Investigator Wölff at knife point. Her demeanor when she was threatening her and her kids. And folks, that's the last fact. The call. Miss Fang kept telling you that Miss Wölff didn't call the police in time, but members of the jury, reasonable time doesn't mean immediately. It means as soon as possible. And today you learn from Investigator Wölff, as soon as her kids were safe, as soon as she herself was safe, and as soon as that criminal was calm, she called the police. Miss Fang kept saying on cross-examination, your words, ma'am. But her job isn't just to get words on the record. It's to prove that Nova Wölff's words cannot be the truth. Today, they failed to show you any evidence of her DNA, any evidence of her fingerprints, evidence of a cage, of any verifiable threats. Because members of the jury, the state's taking Cotter Ashlock in her words, when she's lied dozens of times before. Members of the jury, now you get the final word. And we're going to ask you to find her not guilty because she captured a criminal to stop her crimes. I appreciate your time.
Thank you. Prosecution rebuttal.
Yes, Your Honor. May I proceed?
You may.
Members of the jury, today the defense claimed that Miss Ashlock was free to go. But how can someone truly be free to go when they're threatened with a knife, tied to a chair? Whose safety here was truly at risk? It was Miss Ashlock. Your Honor, 3 digits. You heard today from the defendant herself that it'll only take a few mere seconds to dial 3 digits. And yet, the defendant took an hour to call the police. You see, the defendant said that they were doing it for safety, to safety of themselves and their kids. But the safest option in that scenario would have been to immediately call the police, which the defendant failed to do. That proves how she chose a cage over a call. That's all, Your Honor.
Okay. Thank you.
Now. All right, giving it up to our judges to make some comments. Please take it away.
All right. Congrats, guys. That was such a great round. I thought everybody did such a fantastic job. Just a few quick comments for attorneys. I thought I saw redirect and recross be used more at the end, but I think that's a really valuable tool, and I would have really liked to see it used more throughout the entire trial. But with that, I will say, do make sure that the recross or redirect isn't drifting too far beyond the scope of the previous examination. And then one other thing is that some of you guys did a really great job of referencing case law throughout trial, and I'd like to see that done more by everybody throughout trial as well. But great job to all of you guys. And then for witnesses, I thought you guys were all very engaging to watch, and everybody did a really great job of maintaining their witness character on cross-examination. Although I'd like to see a little bit more fleshed out emotional or character arcs on direct. It definitely felt as if you guys started in one place and then kind of stayed in that place the whole time. So just don't be afraid to add in a little bit more variation. But other than that, great job to everybody.
Hello, everybody. I will say a lot of my comments, at least on the ballots, are more attorney-oriented, as that is what I am most used to. However, both teams did an amazing job. I think you guys did a lot with the few facts that you were given, and it definitely showed. I believe one thing everyone can improve on, attorneys and witnesses alike, is emphasis. It was very hard to keep up with what exactly your side deemed was important or not important, even in speeches or even on direct with the witnesses saying their information. It makes it a lot easier to follow along when you're able to take a breath and take a break from your character bit or take a break from the context of what's happening to really emphasize this really, really important point of your case. So I think everyone can improve on that. However, I did like the objections that went on this round. I feel like every objection was valid in one way or another. I will say better prepare for responses because you know they're going to happen. So there's always at least one way or another to make sure that you know what you're articulating and for the judge to better understand where you're coming from. But both sides did amazing, and congrats.
Uh, Kind of piggybacking off of some of the comments that were said, emphasis is a big thing, and not only just in tone and voice, but also in hand gestures, and that goes for attorneys as well as witnesses. During statements, attorneys, you have your speeches that you're giving. You're using hand gestures to make your points. Be mindful that uh, you know, hand gestures can be used to make your points, but they can also be distracting at times. So make sure that each hand gesture has a purpose. But hand gestures are not just limited to attorneys, witnesses. You can use hand gestures to make your points as well while on the stand. Um, Especially for those who are talking about seeing something or collecting something or trying to lay out a timeline, or something of that effect, or laying out their procedures, or how they felt. Vocal variations and delivery while on the stand as well for witnesses. Sometimes it would get a little bit monotone in your deliveries. Um, Varying it up as you're delivering your story. It would be nice to break it up. Overall, both teams did a fantastic job in terms of your guys' delivery, in terms of presenting your case. But these changes, moving forward, will bump up your presentation. Um, moving forward as you guys get into steeper competition. Uh, so.
All right, big thank you to everybody here. I want to give a special thank you to all of our judges. There was a miscommunication about a change in daylight saving times, which is a relic of actually World War I Germany trying to conserve energy, which I found out as we were waiting around to realize what the discrepancy was. I'm happy everybody was here. Thank you to Judge Gadsden for judging back-to-back quarterfinal rounds. Thank you to Judge Samander for jumping in, having not done IMT before, at the recommendation of the UW-Madison coaching staff. And a special thank you to Tim for not only being the best man/officiant at my wedding, but also jumping on when the third judge, I think, had a conflict, wasn't able to come here. Tim hopped on with about 15 minutes of notice for the love of the game. So thank you to all of you. Let's give the announcements. I know it is quite late, of course, for one team. We're going to start with the MVPs. It was a split decision for the MVP attorney, but winning that decision on a 2-1 from the defense was Christiana Garcia. It is also a split decision for MVP witnesses, winning that split decision from the defense, Ms. Krystal Deng. This takes us to the ultimate results. As the results came in, I decided to compare them to the other three quarterfinals, and I can say with certainty this was the highest scoring quarterfinal overall out of the four, meaning that the judges saw really good things from both teams and awarded you points accordingly. So this is a round that both teams should be proud of. But advancing to the semifinal, to the final four in a 3-0 decision, the defense. Congrats to both teams. Very well done. And I'm going to get you these recordings and these ballots ASAP.